Hi, it's David Lampley from the Dulutri Law Group, and I'm here today to talk to you about when does a debt collector cross the line. A debt collector can cross the line in many ways, many shapes, and many forms that violate the Fair Debt Collection Practices Act. The rule I always kind of keep in mind is they must treat you with respect and dignity. They must not be contacting you solely to harass. Now, the Fair Debt Collection Practices Act does not define these terms or define them and say 3 phone calls in 24 hours is harassment or 6 phone calls over a 2-day span is harassment. It's more left to kind of a subjective standard. I like to tell clients it's one of those things that you'll know it when you see it. For example, if the phone rings every single day at 9 o'clock in the morning, 11 o'clock in the morning, 1 o'clock in the afternoon, and 3 o'clock in the afternoon, that's meant to harass you. That's a pattern of harassment, especially if this continues for days and days and days. Even if they don't get you to respond to them, if they're not talking to you, all of those type of things should be considered harassment and potentially as violations of the Fair Debt Collection Practices Act. What I see oftentimes is when you actually answer the phone and you try to talk to a debt collector. Almost everybody that I meet with wants to pay their bills. It's not something that they don't want to do, but unfortunately, tough circumstances, tough economy, a major medical happenstance has caused them not to be able to make their payments. It's not that they don't want to pay the bills, they've just been unable to. And I hear horror stories where the debt collectors called them deadbeats, where the debt collector has said, why are you paying your mortgage payment instead of paying your credit card bill? These are all things, especially when they start using vulgar language, if they're yelling, calling you a deadbeat, telling you you should be doing this instead of eating. Those are all things that are violations of the Fair Debt Collection Practices Act. And they happen more frequently than, and unfortunately, I think is reported and goes unpunished. So it's very, very important. Now, it's very important to remember that under Florida law, you cannot record the audio recording of somebody without their permission. So what you can do, however, is if you have a pad of paper by the phone and you can write down the time that they called and you can write down what they said, we can get what we call a contemporaneous recording of your thoughts or your memories of the conversation, and we can match this up later if we have to go to litigation against the phone logs. And 9 times out of 10, the debt collector has recorded it and they record the language on there as well. So it's very, very important. The main rule to remember is that a debt collector cannot treat you disrespectfully. They can't try to humiliate you or harass you through phone calls, and they certainly can't be derogatory and call you names. The other thing a debt collector cannot do is they cannot threaten to take some sort of action that they know they cannot take. For example, they can't tell you they're going to have you thrown in jail for not making a payment. They can't tell you that they're going to come in and garnish your bank account and your wages without a judgment. Those things can't happen. They can't just hang up the phone and then go garnish your bank accounts. They have to have a judgment to do those things. A lot of times, again, they use that as scare tactics. They want you to think that you could go to jail. You can't go to jail for not paying a debt, especially if there's not a lawsuit. The only time debt-related that you could go to jail is if you fail to follow an order of the court. But if they haven't sued you, there are no orders of the court.
Thank you for watching. If you would like more information on this topic or any others, please feel free to contact us for a free 30-minute consultation.